Good evening, everybody. Hello, good afternoon, We are starting. There's a hearing just started about the severance for Trump's election case down in Georgia.
All these defendants together. But, Your Honor, I would ask you to please keep in mind that the purpose, yes, you can say the purpose is to elect Donald Trump president. But if that were the purpose, and a prosecutor could use a purpose of that magnitude to try to tie together charges and defendants that otherwise have nothing to do with each other, then, before we know it, millions of people, literally millions of people could have been charged in this conspiracy. These are totally separate cases, Your Honor. And I believe, as you'll see from my colleague, Mr. Aurora, who will get up and talk about the case law. Thank you for allowing us to do that, because he's a lot more on top of that than me. And as you'll hear from Mr. Rafferty, I suspect on behalf of Ms. Powell, it is going to significantly affect these defendants' rights to a fair and impartial trial. Why should Mr. Chesebro have to deal with a jury who's going to sit there for weeks, if not months, and listen to all of this evidence related to Coffee County and Ms. Powell? He's never been there. He's never met Ms. Powell. He's never emailed, texted, or called her. He's never spoken with her directly or indirectly. And although I'm not trying to steal the thunder from my colleague, Mr. Rafferty, on behalf of Ms. Powell, same is to be said for Ms. Powell. Why should Ms. Powell have to sit there for weeks and months hearing evidence and testimony about the alternate slate of elector alleged scheme when she's not even alleged to have any involvement in that? And again, for the third and last time, I'll go back to, I do understand that RICO exists, whether we like it or not. The prosecution chose to bring this case under RICO, although they could have very well brought this case specifically against individuals who are charged with individual crimes, but they chose not to, and that's their discretion. But, Your Honor, that should not override Mr. Chesebro's right to a fundamentally fair trial. It's in the state constitution, it's in the federal constitution, it's in the Georgia code. And I'm really worried that allowing evidence related to all of these other counts and all of these other defendants, in particular, in this case, Ms. Powell, will very seriously jeopardize this. I think, as Mr. Aurora will make clear, it is clearly well within the discretion of the court, if not, as we argue, mandatory to grant this severance from Ms. Powell, and also to grant the severance we asked for related to the counts that don't affect Mr. Chesebro. So with that, Your Honor, I'm sure you'd like to hear some case law or supporting authority. So I will let my smarter co-counsel, Mr. Aurora, get up and deal with that. Thank you.
So, guys, this is the severance hearing for Kenneth Chesebro and Sidney Powell to separate their cases out.
Motion do you want me to address first? The severance of the counts or the parties?
Yeah, why don't we dive into the severance of defendants? I think that's the one that we might have more to talk about.
All right. Well, I think Your Honor, when you were a DA, probably battled against each other on some of these types of issues, trying to get severances together, but that was in another lifetime, I guess. I've tried to put most of the case law that we've got that's in the briefs, because in the end, I'll give you some more 2023 cases that just came down a couple of weeks ago, both federally and in the state system. But in the end, I think a fair assessment is it's your decision. I mean, there's nothing that says if X then Y or if Y then Z. It's just basically you're gonna have to weigh the options. Is it my voice or is it ringing?
There might be a little bit of a feedback.
Okay. So with regards to the severance, with regards to Ms. Powell, I'll go ahead and start the court off with Henderson versus State, and I've highlighted it for the state. And may I approach, Your Honor?
Sure.
Judge does not sound like thrilled, so that's not a good start.
And if you go towards the second to last page on the back, I've highlighted that for the court and for opposing counsel. So as you'll see,
That's how you do it.
Head notes 40, 41, and 42. Like it says, everything's basically in your discretion. But in this case that just came down a couple of weeks ago, what we were talking about is sort of highlighted in regards to sort of similarly the facts in our case, right? The first issue is going to be, is there going to be any confusion about the evidence? Are there conflicting defenses, antagonistic defenses? And in the end, is there going to be confusion as far as that goes? There will not be any antagonistic defenses because the two people don't overlap at all in the indictment or any evidence that I've seen. The issue is going to be what's the confusion, and one of the remedies is obviously jury charges. And in your case, the question becomes, how many jury charges can you bring, can you provide to the the jury, as far as trying to understand all these types of things. So this case that I gave you is a RICO case involving gang-related type charges. And what it basically says is those two people were charged with the same crimes. And in the end, the court didn't sever those matters. We don't have that here right out of the gate. There's no antagonistic defenses. So I'm not going to get into factor 3. There's really just overflow and spillover as far as that goes. And so the question is the evidence against Ms. Powell going to impact her? And the reason I say that is we're charged in the RICO and then 6 predicate acts. The predicate acts only deal with the elector slate as far as who filled out the electors, was that fraudulent or not. With regards to what happened in Coffee County, you're going to have a ton of other charges from witness intimidation, computer hacking, fraud that has nothing to do with Mr. Chesebro. The other thing you look at is, are these other pieces of evidence going to be similar transactions potentially, which wouldn't be in this case because they have nothing to do with one another. There's nothing similar about it. So when the government argues that it's RICO and we get to bring in anything in the kitchen sink, I think the cases that I'm going to cite you, there's a couple more also from 2023 that talk about, yeah, you can bring in everything. And it's mostly been like gang RICO type cases or some type of violence that's out there. It still gives you an out based on what you think. And the reason I bring these up is in all those cases, everybody's charged with the same things. Here, they can argue that it's a similar activity, but not to speak for Ms. Powell, but essentially from what I understand from the public record is she was fired before this conspiracy actually even started up because she said something that was supposedly crazy and the Trump people got rid of her, and whatever she did was sort of on a lark on her own as far as Coffee County goes. That's just my understanding from the public. Again, I just want the court to focus in on what type of evidence would come in against Ms. Powell versus what we're charged with, which is solely paperwork and legal opinion on 3 different memos and some emails.
Yeah, that's all Chesebro
So
did.
with that,
He did his job.
approach the court on a RICO case that dealt with drug dealing. That just came down in the federal court in March of this year. It's out of the 9th Circuit. Again, I've highlighted everything that's
You still
that I
highlight
believe
everything
to be
and keep it
relevant with
together.
regards to this case.
Mr. Rowe, what's the site on that?
The site will be
This is the
2023
lawyer
Westlaw
for Kenneth Chesebro.
2620418. And if Your Honor would look at just above head note 7, it's going to be about 3 or 4 pages in. I realize the bottom of my pages have sort of been cut off, but it would be if you just fold over 3 pages, and I've highlighted it. And so again, there they talk about co-defendants being charged in conspiracies and, you know, why there's a joinder in these matters. But again, factually speaking, if you look at it, the charges are the same against each person, and then the severance isn't necessarily going to change anything as far as that goes. And again, I know I'm repeating myself, but we don't have similar charges. It's completely different if you look at the indictment as far as that goes. Again, I'll emphasize, we are charged solely with the elector portion and the ballots that they filled out that were sent up to Washington, D.C. versus Ms. Powell isn't charged with any of that. She's charged with, I guess, computer fraud and some other things as it goes to Coffee County. And lastly, before I rest on this part of this argument, the Seminole case that came down dealing with suppression
Seminole.
would have been Zafiro versus United States back in 1993. And this also is a drug conspiracy because almost all the RICOs and the conspiracies, unfortunately, dealt with drugs and violence, and this is sort of an outlier.
Yeah,
or
this
a
is
case of first
rare
impression for all of us
RICO
here.
conspiracy.
And if Your Honor goes to the head notes that are labeled 8, 9, 10, 11, 12, and 13 on the 3rd page over, they talk about the risk of a fair trial in this situation. Again, in Zafiro, they didn't grant the severance because the parties were interacted, and they just mostly talked about antagonistic defenses because one co-defendant would say the other guy did it, I didn't know anything about anything. But they also talk about what evidence could have been admitted that wouldn't be considered against someone else. And so in our position is, if you look at Georgia case law, it talks about, would they be similar transactions so they could come in or some other vehicle? None of that exists here in this case. And like Mr. Grubman said, they're essentially different mini conspiracies within this entire RICO Act.
And so what evidence are you pointing to that's inadmissible in your trial than would be in another?
With regards to Ms. Powell, we would object to a lot of that stuff because it would impugn our character as far as being associated with somebody, which they'd have to prove. Now, granted, it's admissible if we're going to trial together, but you would have to give limiting instruction after limiting instruction after limiting instruction as far as that goes.
Yes, you
And
would.
at some point, if we're going for a week or a month or however long the trial is, I don't want the baby to get thrown out with the bathwater. That's why I'm emphasizing. We are charged with sort of the intellectual part of this case, right? We wrote some memos talking about how the ECA and the 12th Amendment works, and that's a separate motion we filed that we'll need to take up in the future about those issues. And then specifically in Georgia, we sent 2 emails to the head of the Republican Party as alleged. That's it. In the RICO counts, there's 160 some odd overt acts. As the court knows, there's an overt act, which doesn't have to be a crime, and there's predicate acts. We are not labeled as having committed any predicate act in the RICO conspiracy in this case. We then have 6 substantive counts, all that deal with whether the electors are fraudulent or not, and whether they filled out the paperwork was forgery or not. That's essentially all of it. With her, you don't have that. You've got what happened in Coffee County as far as, did we have computer fraud, computer trespass? Did we intimidate people? Were we suppressing the vote? Things like that, I've read about and I've seen the public atmosphere, which is going to come up. That has nothing to do with us. Our whole point is we were 1,000 miles away from here. We wrote intelligent memos based on our experience in the Gore versus Bush campaign, which we also worked on. And we basically said, if there is a valid underlying offense, then the ECA and those arguments that I'm making could be valid. We had nothing to do with the actual shenanigans, allegations, whatever in the state of Georgia necessarily themselves. And that's where I'm trying to distinguish it, because you could very easily say it's just 2 defendants. So there may not be a confusion of who's what.
Rob,
but you're
hello. How are
essentially
you
running
doing?
2 trials simultaneously in here. And so I don't think giving limiting instructions with me objecting to all of it is fair. And I think that's what Zafiro and some of the other cases talk
Hello,
about.
hope you're doing well.
And I brought those up because even though they ruled against us and everything, the analysis was relatively sound. And in the end, it says you can do what you wish because there is no specific X then Y situation. So that would be my argument with regards to Ms. Powell.
So let me
know if you guys
unpack a few
can
of
hear
those,
me here.
'cause, so under the kind of traditional 3-prong metric we're looking at, one of the recurring themes is spillover evidence. And if you're saying that essentially what we've got are 2 different trials or 2 different conspiracies that have been joined under this umbrella, and you said that Mr. Chesebro never even interacted or knew Ms. Powell in any way, where's the spillover there? If they've actually never interacted and these counts are entirely separate, as you keep kind of pointing out.
Well, the spillover is essentially, we can't hide sort of the elephant in the room that sort of overglosses all this stuff. I don't know what evidence the government's going to try to present with regards to how they prove the RICO conspiracy or the knowledge or those types of things. What I'm saying is, yes, there's going to be separate evidence going up against Ms. Powell, but at some point, the sheer volume of it all, there's going to be sort of a connection. We're sitting at the table together, and that carries a lot of weight. Your Honor's one of the very few judges that's done a ton of trials as far as that goes, and you know the impact that's going to have as far as that goes. There's just a reality. I don't know if there's a legal theory that says it out there, but you and I both know that's going to happen.
And I'm not discounting that it might be, obviously inconvenient and burdensome, and it might take a lot of time. But do we have any case? You cited to the Price case,
Yes,
I think, as a reversal of a denial of severance.
Yes, sir.
Have there been any other cases in the 43 years since then where a denial of severance was reversed?
It's incredibly rare. I haven't found it. I'm sure somewhere in this country that's happened as far as that goes. But what I was trying to say is severance traditionally, even like when you and I interacted, is in a group of 3 or 4 people accused of committing a crime together. Specifically, you murdered this guy or you sold these drugs, you did this. It's not you sold drugs, you murdered on a separate day, a month apart, whatever it might be. There's a time lag here. There's a completely different set of facts that go with it. There's no interaction or knowledge as far as the parties go. So there's no way for us to presume how much damage that the evidence against one person might eventually spill over, regardless of the instructions. And that's what I cited to you in the Griffin case, out of Georgia from 2000 by the Supreme Court. It's a decision you have to make. I can't presume any of that, but having a ton of experience, you having a ton of experience in trials, that is a substantial risk.
100%. There's going to be a lot of
fair trial, because
damage.
her charges are way more provocative versus the boring old charges that we have as far as just sort of the paperwork type situation. And that's what I worry about, because it tinges on racial issues, voter suppression, all those kinds of things are going to come up, based on what's happened in Coffee County. And that scares the heck out of me.
So are you saying that in line with Price? I think the way Price has been distinguished over the years is one defendant had overwhelming evidence and the other defendant didn't really have much. Are you saying there's a defendant here who has overwhelming evidence as compared to your situation?
Well, I don't have discovery yet, so I can't necessarily say. I can just base it on what I think the evidence is going to be. I don't know if I'd call it overwhelming. It's completely different, and I'm sure there's going to be a ton of it from what I've seen in the TV coverage and the public media as far as people speaking out on Coffee County. Whereas on our side, we'll have intellects talking about, is the ECA constitutional, is it not? What is the 12th Amendment? I mean, frankly, Judge, prior to this case, I didn't even know what the 12th Amendment was because I'd never even thought about it. I don't know if anybody in this room had really thought about it, or the ECA. It was just people vote and somehow it all works out. And so I've had to learn a lot of that stuff. It's just a completely different trial. I think you can see that in sort of reading just the indictment in
This
itself.
is that judge's voice. He
And
doesn't
that's the
sound
fear.
scared
At
already.
some point, do we just sort of mix it all together and stop paying attention? I don't know. And then how many limiting instructions are you going to give in this case? Is it going to be before every witness that comes up against Ms. Powell, which of
Not
course
scared
I'll
at all. Very
object to is
confident.
not relevant to us, and impeaching and all these kinds of things. And so I just think it'd be easy to have a clean trial. It'd be a much shorter trial, in my opinion, as far as that goes. So that would be my position, and we'll
talk about this in a minute.
address it, and then I can address the second issue.
Why don't we just go ahead and, since you're up, we'll talk about severing counts, because that one I wanted to make sure I understood exactly what you were asking for. Are you saying there should just be a redacted indictment if you proceed to trial alone? Or are you saying that the state shouldn't be allowed to introduce any evidence other than what Mr. Chesebro has specifically been charged with?
What I'm asking for is a redaction, and we typically do that on cases where we have hearings on certain charges or co-defendant falls out. If there's multiple murders or multiple drug deals, you sort of block it out. I don't know how else to phrase it except for maybe a severance of counts. We have 7 counts. I get it. I don't necessarily think they're related, but I'm not going to challenge that because the law is weak on those issues. The 34 other counts involve a total of 13 defendants that we're not affiliated with. Our counts are involving 6 total people. But the other 34, again, as Mr. Grubman said, are multiple conspiracies within the conspiracy, and I don't see how that's relevant or even admissible in this case. It's not similar transaction material. So I'm just asking it to be redacted, I guess, if that's the correct word, because we're not being judged on those counts. So we shouldn't be telling the jury all this kind of things, just like you'd redact some of the names in the indictment.
So to be clear, it's more just a logistical thing that the jury would get an indictment that's been changed just to reflect your case, not that they couldn't have witnesses talking about the entire RICO enterprise as they allege it.
Right. I'm not saying that all that's a matter of different objections down the road as to admissibility or relevance, but on this matter, I'm just saying the jury shouldn't be seeing the other 34 counts that are out there, or the, I guess, 18 other defendants or 17 other defendants that are out there. I did cite Durden as far as your discretion, but that's, again, more about counts I've been charged with trying to sever, something apart. We don't have that time distinguishing. All our actions are within basically 2 weeks. So I'm not going to waste your time with that. I'm just saying what the other 34 counts deal with, the time frames are different, the people are different, the charges are different. And so I would just like a sanitized indictment, whether we go alone or with Ms. Powell as to those counts, because I think the court can see, obviously, there was some prejudice there, having to read off a 98-page indictment when only, I think, 6 or 7 pages apply to us.
Okay, fair enough. Thank you, Mr. Aurora.
Yes, Your Honor. And will I be able to rebut if the government chooses?
Let's see where we go.
Okay.
Good afternoon, Your Honor. The case against Ms. Powell is in a slightly different procedural posture than against Ms. Chesebro, and I just thought it appropriate to sort of start with the fact that we filed a speedy trial demand within a day or two of the speedy trial demand of Mr. Chesebro. Mr. Chesebro, and we have not yet received a scheduling order or a ruling or anything else about when the trial of Ms. Powell will occur. My experience as a former federal prosecutor and in federal court under the Speedy Trial Act is in situations where you have multiple defendants like this, if one defendant makes a demand for a speedy trial or two, as we have here, the court has the discretion under the Speedy Trial Act in federal court to still push the case down because some other defendants, as we have in this case, have said they're not ready for trial. That's ordinarily what happens in federal court. But here in state court, looking at the state law and the State Speedy Trial Act, by virtue of our demand, and the various severance motions that other defendants have filed saying they're not ready for trial, I think Ms. Powell has to be severed out from the remaining 17. And so the question for today, in my mind, is whether the trial of Ms. Powell will be joint with Mr. Chesebro or not. I think based on all of the law that I've seen, and I haven't seen anything to the contrary, her demand for speedy trial cannot be trumped by the desire of the government to try everyone together when other defendants have moved to sever and said they're not ready. And so that's sort of the first point I wanted to just make is although the court hasn't issued a scheduling order, I think we are on the same path as Mr. Chesebro about when this trial should happen, which leads us to sort of the second question about whether or not Mr. Chesebro and Ms. Powell should be tried together. And I echo many of the things that my co-defendants counsel have said, although I have a very different view of the evidence and the evidence as it relates to Ms. Powell. I'll just point out in the indictment, the government was kind enough to list on page 16 or 17 or 18 a summary of the various manner and means of the indictment. And if you look at that, you'll see that Ms. Powell had nothing to do with most of it. Ms. Powell had nothing to do with false statements to state legislators, nothing to do with false statements to high-ranking government officials, nothing to do with false electoral college documents, nothing to do with the election worker here in Fulton County, nothing to do with solicitations of the Department of Justice, nothing to do with solicitations to the vice president. The only thing which she's alleged to have involvement is, as my co-counsel have said, is this Coffee County matter. And frankly, Your Honor, the way the government has characterized that, the evidence is going to show they're incorrect. She was not the driving force. The evidence will show that she was not the driving force behind that there were other lawyers not mentioned in this case that were actually the driving force behind that. We've submitted a Brady request already to the government before this hearing, asking for a host of different kinds of exculpatory material that we believe the government has that will show that she was not the person that was behind this has been alleged in this indictment. Her typewritten name does appear on a contract, but she never signed the contract. And the contract isn't even for Coffee County. It's for another state. And she never signed it. And the most important part of this case, Your Honor, with respect to the Coffee County aspect of this case is the question of authorization and whether or not the visit down there was authorized or not. And there's a lot of public documents that are out there that demonstrate that numerous folks associated with Coffee County authorized that visit. The video itself shows that. Ms. Powell's name appears maybe a dozen times in this indictment. She has nothing to do with the electoral college aspects of this, which is going to involve all sorts of complex testimony about constitutional issues and things of that nature. Her only involvement, as alleged by the government, is what happened in Coffee County, and even that they have wrong. So why does that matter? Because my presentation, my cross-examination, my case is going to depend on my ability to present to a jury that she had nothing to do with what the government says she was involved in Coffee County. The evidence is not going to show what they say. But all of that, all of my efforts is going to get washed away in days or weeks of testimony, perhaps, about the Constitution and whether or not and under what circumstances and alternative electors can be put in place and whether the legal opinions of Mr. Chesebro and others have any sort of legal validity. All of that is going to be prejudicial to my client. She's going to be sitting there for days, if not weeks, listening to this kind of testimony when the case as to her in Coffee County really boils down to one day, January 7th. That's it. The whole case is about whether or not that visit was authorized and what, if any, role she had in it, which is very little, if none. So, you know, she's going to be prejudiced by all this other testimony about things that she had nothing to do with. And as a matter of judicial economy, you have discretion, as my counsel have said, you have the discretion to make a decision about the interest of judicial economy. I don't think a trial about Coffee County, if that's what we have a trial about, is going to take weeks or months. I think the trial could be over in a couple of days. Most of it is on video that a lot of folks have seen, and there's a handful of emails, and that's really it. There isn't that much evidence. And so when the court thinks about its discretion about how it can exercise that discretion and move this case along, move Mr. Chesebro's case along, the best way to do that, frankly, is to try the cases separately. And I would ask the court to just exercise the discretion that it has, that my co-counsel have already set forth, and sever Ms. Powell's case for Mr. Chesebro so she can get a fair trial. I'm prepared to answer any other questions, Your Honor. I think I've laid out my arguments.
Let me take up one
very strong argument.
The traditional framework,
like a machine gun, right there.
Mr. Chesebro,
that was good.
Team took
very
this up,
good.
but one of those obviously is the antagonistic defenses. Are you joining their position that you don't anticipate that being a consideration here?
I don't think that there's antagonistic defenses because as my co-counsel has said, my client doesn't know Mr. Chesebro, has never met him, has never really spoke with him. There's no emails or documents or anything else. What he's accused of has absolutely nothing to do with Ms. Powell at all. And so I don't see that as antagonistic. It's just that evidence presented at a trial with Ms. Powell is going to prejudice her in the same way that Mr. Chesebro's lawyer said that evidence about whatever Ms. Powell did would prejudice Mr. Chesebro.
Okay.
Thank you, Your Honor.
Thank you, sir.
Hey, that choose fire.
That's why Mr. Wooten is chomping at the bit to address some of the arguments that counsel has made. I'll just briefly lay out a few things that the court has asked the state to be prepared to respond to. Firstly, we will contend that a trial of these 19 co-defendants will take 4 months, and that does not include jury selection. And it's also predicated upon whether or not, of course, the defendants elect to testify or not. But 4 months is our time estimate. In terms of the number of witnesses, there are in excess of 150 witnesses that the state intends to call. 150 witnesses. Judge, we contend that we must prove the entire conspiracy against each and every one charged. Each and every one charged. So the court, in the interest of judicial economy, would have to make the decision as to whether or not the court wants to try the same case 19 times or 2.
So, to be clear, when you say 2, is your position evolved from your filings of last week or from lately?
It hadn't, Judge. I just throw out the number for just to give the court the difference in the number of times and the number of man hours it'll take to try the case, once or twice.
Well, when you say twice, who's involved in each case?
Obviously, the 2 who've requested severance here.
All right, because up to this point, I thought the state's position was all 19 need to go on October 23rd.
It is, and that continues to be our position.
Okay. And just to clarify that and flesh that out a bit, you're saying that right now you would predict that if it was just a trial of Ms. Powell and Mr. Chesebro, that the state's going to need those same amount of witnesses, those same amount of exhibits, and that same amount of time?
Absolutely.
Okay.
Your Honor, for my portion, I do have a PowerPoint. How does the court prefer that I do that?
Well, I think we'd have to get you on the Zoom call so you can share a screen.
Okay. Just a moment.
Do you have a link for that?
I do not, Judge, but
All right, let's see if we can email you that.
Oh, fuck. Okay. All right. So Chesebro and Powell are obviously in the RICO case. They're trying to break off. They want to go way over here and be tried separately. And I don't blame them, because otherwise you're going to introduce all the nonsense about everything else that went on, and they were involved in it. So, like they said, it's like, okay, I did a crime, and then these other guys did a bunch of other stuff, including murder. They don't want that prejudicing their client. So it shouldn't be muted anymore. God, you guys are assholes. So there is any way to turn the sound up on the court stream? I can do this. I can do the stream. But getting through some questions. So this is the severance hearing. This is what it's about. And I will jack up the sound. Get ready, guys. It's going to get loud in a second. Hold on here.
Judge, I'm not seeing that email come through.
Gonna have to turn your sound down on your end.
Just hold another minute.
Okay. So that's the sound right there. Aaron saying sort of the civil rights up to the government's convenience. Not necessarily in this case. I mean, everybody has rights. And they mentioned in the federal court, the Speedy Trial Act. That doesn't exist at state level. So generally, it's the defendant's choice to invoke speedy trial. Lacey Ann saying, I like this attorney. He's good and prepared. Yes, very well prepared. Sidney Powell's attorneys are hitting it hard. It's going to be interesting what they have. And then there's a, so this is Powell's defense argument. Essentially, it was set up by an unindicted party. Sounds like it partially, but it sounds like they don't have a lot tying her to this. It's interesting. There's no agreements. She hasn't signed any to do any work in Georgia. So there's a lot going on here. So it'll be interesting. It looks like we're back, though.
Court, but I could convert that to an exhibit if the court prefers.
Sure.
Okay, here we go. Netflix letter things. My client from last week's sentence yet? No, probably later this month. And Chadwick, this is correct. There's no case law to cite because it's all like criminals and drug dealers and gangbangers that ever get tried on this, not some asshole prosecutor trying to ruin things. I mean, yeah. So it's hard. It's hard to say, Your Honor, I have a case on point for a novel situation, and this is really novel. This is first of its kind. Guys, if you enjoy this, please click like below. Let's take it to the algorithm. Doc H, 20 seconds behind the baseline. Yes, Raka Fraka says, Your Honor, we'd like to make this much more complicated than it needs to be. Kevin saying, is this judge, the white guy's up? Well, the white guys are always up to something. Careful about white people. Kevin H says, that guy's black. True. Eliza Krogan says, is this judge Democrat or Republican? I don't know. Fire says, you're into stuff for streaming this. Well, thank you. I appreciate it. You guys don't mind subbing. Appreciate it, but yeah, likes always.
I've got the meeting ID. I just don't have the passcode.
Stand by for another email.
This is how things go in court when you're dealing with electronics. This crap happens all the time. Oh, I'm ready. I'm not. Oh no, this happened. That happened. There's probably going to be an issue now where we try to play it and it's not going to work. So this is entirely normal. This happens all the time. Yeah, bass player. I agree. I don't see this trial being done in 4 months. Remember, Young Thug, the YSL gang case, 6 months already, and the jury's still not done. So I don't see how they think they'll be done like this. This is who we are says, yeah, I saw that. I gotta run that down and check what Noel was talking about. Reform Convict saying, if this is legit RICO, why couldn't you convict the whole Republican Party if that's the case? Don't give them ideas. Don't give them ideas. Oh, we're back.
Your Honor, I'm just going to quickly move through, of course, the statutory and case law parameters under which Your Honor has to make this decision. 1784A, of course, states that when two or more defendants are jointly indicted, such defendants may be tried jointly or separately in the discretion of the trial court. And our case law, we're relying on Collins versus Estate 312, Georgia 727. Three factors to consider are the likelihood of confusion of the evidence in law, the possibility that evidence against one defendant may be considered against the other defendants, and the presence or absence of antagonistic defenses. And I guess the position of the other side is that neither is saying that three is an issue, that there doesn't seem to be any antagonistic defense. Of course, neither the mere presence of an antagonistic defense nor the possibility that a separate trial will give a defendant better chance of acquittal is sufficient to sever. The defendant bears a burden of showing that a joint trial would be so prejudicial as to amount to a denial of his or her right to due process. So I want to talk about what's not a proper ground for severance first. And this is coming from Mr. Chesebro's motion to sever. He says, in sum, there has never been any direct contact or communication between Mr. Chesebro and Ms. Powell. Similarly, there is no connection or overlap between the overt acts or the substantive charges associated with Mr. Chesebro and Mr. Powell. That is not a defense, and that is not a ground for severance. Similarly, Ms. Powell's motion says that Ms. Powell can receive a fair trial only if she's tried alone. The prejudice that would inure to her from a lengthy trial with any of those she was not involved with, and about the vast number of events she had no knowledge of or connection with, would deny her due process. Again, not a defense, not a ground for severance. Turning to case law, Lowry versus the state, 347 Georgia App 26, a 2018 case. Nothing in Georgia's RICO provisions requires that Lowry, the defendant in that case, have participated in or even been aware of all the alleged acts of racketeering activity committed in connection with the common enterprise. Thompson versus the state, also Georgia Court of Appeals. None of the provisions of the Georgia RICO Act requires that each defendant in an enterprise have full knowledge of all facets and elements of the enterprise and all of its members or actors. And likewise, the federal courts agree. This is an 11th Circuit case, 1996, United States versus Castro. In proving the existence of a single RICO conspiracy, the government does not need to prove that each conspirator agreed with every other conspirator, knew of his fellow conspirators, was aware of all the details of the conspiracy, or contemplated participating in the same related crime. And so we've heard a lot from both defendants about they didn't know the other people. They were located thousands of miles apart. They didn't even know that the other parts of the conspiracy were going on. But the case law is clear that that does not matter. Of course, anytime a person enters into a conspiracy, they are liable for all of the acts of all of their co-conspirators. And that's it. Evidence against one is evidence against all. And as Mr. Wade noted to the court, the state's position is that whether we have one trial or 19 trials, the evidence is exactly the same. The number of witnesses is the same. And so many of the arguments that are made on the other side evaporate. I want to look at the cases that were cited by Mr. Chesebro in his motion. Griffin versus the state, that's a case where severance was properly denied. It is not a RICO case. Brown versus the state, another case where severance was properly denied, not a RICO case. Baker versus the state, severance was properly denied, not a RICO case. Padgett, severance properly denied, not a RICO case. Jones versus the state, severance was properly denied, also not a RICO case. Zafiro versus United States, federal case. Again, severance was properly denied. That was not a RICO case. Henderson, which we just received just now, that was also not a RICO case. Severance was properly denied. Mr. Chesebro points to a couple of cases in his motion where a conviction was reversed on appeal. And as the court pointed out, in those cases, what the appellate courts found was that at trial, the evidence against one defendant was minimal, almost nothing compared to the evidence against the co-defendants. And so it was just fundamentally unfair that there was all this evidence that applied to one, very little that applied to the other, and the jury may have been confused. Look at defendant Powell's list, and most of these are the same, so I'll click through them. Again, same cases, most of them severance properly denied, none of them a RICO case, and the ones where a conviction was overturned on appeal, again, it came down to insufficient evidence at trial. The evidence against the defendant named was just so minimal compared to the evidence that was pertinent to the other defendants charged. And of course, conspiracy cases, and more specifically, RICO conspiracy cases are different. And that's why we point out that all of those cases relied on by the other side are not RICO cases. And so the analysis is different. The facts are different and the law is different. Looking to our Georgia courts, Pasha versus the state, 273 Georgia App 788, 2005 case. Each actor in a conspiracy is responsible for the overt actions undertaken by all of the other co-conspirators in furtherance of the conspiracy. Willingham versus the state, Georgia Supreme Court case 1995. where there's sufficient evidence of a common scheme or plan to commit a criminal offense, joinder is authorized. And our federal courts kind of take both of these concepts.
Authorized, not
In the United States
mandatory.
versus Caporale, 806 F. 2nd, 1487, an 11th Circuit case here in Atlanta in 1986. Joinder of co-defendants in a count charging a single RICO conspiracy violation is permissible, even if different defendants are charged with different acts of racketeering, if the racketeering acts charged are in furtherance of the overarching RICO conspiracy charge. And in our case, the state's theory of the case and as laid out in the indictment, each and every one of those 161 overt acts charged and all of the offenses charged from count 1 to count 41 were all in furtherance of the same overarching RICO conspiracy, which was to unlawfully affect the outcome of the 2020 election in the state of Georgia. Every single one. I understand the other side's argument that, my clients over here in Coffee County, my clients over here in Wisconsin or wherever sending off emails. But the problem for them is that it doesn't matter because it's all part of the same overarching RICO conspiracy. And the state's theory of the case, as alleged in the indictment, is that as this enterprise operated in multiple states and operated quite a lot in Fulton County, that's why we have this case here in Fulton County, the conspiracy evolved. One thing didn't work, so we move on to the next thing. That thing didn't work, so we move on to the next thing. That thing didn't work, so we move on to the next thing. And that was going on from the first overt act to the last overt act, all part of that same overarching RICO conspiracy. Turning back to the factors that the court needs to look at, and I'm just going to kind of talk about factors 1 and 2, the likelihood of confusion of the evidence in law, the possibility that evidence against one defendant may be considered against the other defendant, or 3, which the other side agrees is not an issue here. But 1 and 2, because this is a RICO conspiracy case, and because the evidence against one is admissible against all, 1 and 2 evaporate. There's no likelihood of confusion about which evidence applies to which defendant or which law applies to which defendant when all of them are alleged to have engaged in the same conspiracy. And it's significant that in count 1 of the indictment, the RICO count, the allegations set forth in counts 2 through 41 are all included in that count 1. And so while, Mr. Chesebro may have never been to Coffee County, the evidence about Coffee County is evidence that the enterprise existed and shows that the enterprise was working. And because it's a conspiracy case, Mr. Chesebro is liable for what happened there, and it's admissible evidence. Again, going back to our federal court, since any evidentiary spillover, and the court asked about this issue, since any evidentiary spillover is vitiated, where the evidence in all events would have been admissible against the movement, in the context of a conspiracy, severance will rarely, if ever, be required. This is a First Circuit Court of Appeals case, and we submit that as persuasive authority here. Again, turning to another example, United States versus Diaz, a Second Circuit case from 1999, and a federal RICO conspiracy case from the Second Circuit involving the Latin Kings. Even when a defendant was implicated in only one of 9 separate murders carried out as part of a pattern of racketeering activity, a joint trial was proper because all of the evidence was admissible against each and every one of the defendants to show multiple things, not just that they committed an act, but to show the existence and nature of the RICO enterprise and to show a pattern of racketeering activity on the part of each of the RICO defendants, as well as his or her relationship with the enterprise itself. And I just love this quote because I think it sums it up. Again, it's an 8th Circuit Court of Appeals decision, persuasive authority, but there in United States versus Kehoe, the 8th Circuit said that it will be the rare case, if ever, where a trial court should sever the trial of alleged co-conspirators. The other side pointed a little bit to this, but I did want to mention that any potential jury confusion can be addressed by other means other than severance, such as an instruction to the jury to separately consider the evidence as to each defendant. Now, again, the state's position is that because this is a conspiracy case, because it's a RICO conspiracy case, that all of the evidence is admissible against all of the defendants. But even if that, even if there were some issue or to be extra cautious, the court could give a limiting instruction. And the state's position is that it would not be limiting instruction after limiting instruction after limiting extra instruction, because again, all the evidence is admissible against all the defendants. Also, the defendants completely ignore a long line of cases in Georgia that affirm the denial of severance for Georgia RICO Act violations, all decided under these same principles that I've just talked about. First, Chancey versus the state, Georgia Supreme Court, 256 Georgia 415, a 1986 decision, Evans versus the state.
I think we've got the sites here. We can
Okay.
look at those later.
Sure. And those are provided to counsel, and Your Honor, I have copies of those as well for you. So under these principles, the defendants cannot satisfy the first two prongs: likelihood of confusion of the evidence in the law, the possibility that evidence against one may be considered against the other, because that's allowable. That's exactly what a RICO conspiracy case is allowed to do. I don't think I need to talk too much about the third prong because of the statements of the other side. Just would hit that defendant has to show that a joint trial as it relates to the third prong would have to amount to some sort of a denial of a due process right. And we don't believe that's the case here. Palmer versus the state, just to point out a few, Georgia Supreme Court case where the Palmer court highlighted certain situations where there was an antagonistic defense, Barge, Metz, Lauren, and again, won't get into those because of where we're at. But the bottom line there is that it has to be prejudicial as to amount to a denial of his or her right to due process. Also want to talk about public policy. Public policy, and our courts have hit on this issue, strongly disfavors severance in complex conspiracy cases for several reasons. One is judicial economy. There's been arguments on the other side that somehow severing any of these defendants out would be more economical. I'm not quite sure how that works. I think one 4-month trial is shorter than multiple 4-month trials. Same witnesses, same evidence. Minimizing the inconvenience and trauma on victims and witnesses. And I want to remind the court that part of this RICO conspiracy involves victims. There are victims in this case that were targeted by members of the enterprise, and their lives were turned upside down. And that's an important part of this case. And having those people come and testify multiple times over and over would both inconvenience, but more importantly, traumatize them.
Yes, well,
Consistency of the verdicts. And I've got a little bit of case law that talks about that. Efficient use of state resources and fundamental fairness. Justice Scalia astutely observed, it would impair both the efficiency and the fairness of the criminal justice system to require, in all these cases of joint crimes where incriminating statements exist, that prosecutors bring separate proceedings presenting the same evidence again and again, requiring victims and witnesses to repeat the inconvenience and sometimes trauma of testifying, and randomly favoring the last tried defendants who have the advantage of knowing the prosecution's case beforehand. He goes on to say, joint trials generally serve the interests of justice by avoiding inconsistent verdicts, enabling more accurate assessment of relative culpability. And he points out that these are sometimes advantages that operate to a defendant's benefit. So even apart, he says, from these tactical considerations, joint trials generally serve the interests of justice by avoiding the scandal and inequity of inconsistent verdicts. And our Georgia courts agree. They agree that economic use of resources is an important and legitimate concern. Montgomery versus the state, 156, Georgia App 448, a 1980 case. In a case where the same witnesses, the same evidence, and the same charges would be used against all defendants, thus affecting judicial economy in the use of physical facilities, time of witnesses, jurors, and court personnel. The trial court must consider these efficiencies against the possible conflicting interests of joint or multiple defendants. And the 11th Circuit again agrees. United States versus Brown, 2007 decision 505 F3rd 1229. We find considerations of judicial economy to weigh heavily against severance in light of the substantial systemic interest in handling this complex conspiracy case in one trial. And in that case, it was a 2-month trial. State, as we've represented to you, Judge, believes that this would be at least a 4-month trial. So defendants, the state's position, have not met their burdens as to any of the factors set forth in Collins. The case presents no likelihood of confusion of the evidence or law applicable to any defendant because all of the evidence is applicable to all of the defendants. All of the law is applicable to all of the defendants. And 2, evidence against any defendant may properly be considered against each of the defendants in a RICO conspiracy case, so there's no risk of this spillover effect. Just to mention 3, again, they concede that that's not an issue here. That's all I have, Judge, unless you have any questions.
Just a few. So these, again, the 3 factors, those are just, would you agree that those aren't exclusive?
Yes, Your Honor, absolutely.
All right. So we're really supposed to take into consideration the circumstances of the entire case and anything that just might be present in this case. It may not be in others, right?
Yes,
Yes,
non-exhaustive factors.
So I guess some of the things I think we need to think through, to me also, it's more this position that we still need to have all 19 people at the table 47 days from now. And maybe this is something, if you need to tag team in with somebody else on the council, one of the first things I kind of want to talk through is potentially how removal affects this. So I know your estate is currently litigating this issue with multiple of the co-defendants in federal court. And while that's happening, until a decision is made, we can't issue a judgment of conviction here, right?
Yes, Judge.
Now, no matter how Judge Jones rules, isn't either party going to have the right to appeal that ruling?
That is correct, Judge. Our position is that both sides would have the right to appeal.
And so the 11th Circuit could take any idea of how long to weigh in?
As long as they need to.
Right. So it could potentially even optimistically be a 6-month turnaround just for the 11th Circuit to come up with a decision, right?
Yes, sir.
So if it's a 4-month trial that starts in October, we're potentially sitting at a point where we presented the entire state's case. Maybe even the jury has returned a verdict, but we can't enter that judgment of conviction until the 11th Circuit comes to a decision. Is that kind of the scenario we're playing out here?
Judge, I think.
Excuse me, if we can have a moment, Judge.
They're out of their goddamn minds if they think they're going to try the case and then just hold off on the ruling. Holy Jesus. No. No. Sorry guys, you couldn't hear me at the same time. I apologize. Oh, here we go.
Wasn't something that I highlighted. So if this is something we need to submit for, post-hearing briefing, we can do that. But this is something that I think is a consideration we ought to be taking into mind.
Sure. And that may be the best route, Judge. Our kind of position on that is it depends on what the scope of Judge Jones's order is. If he takes the position that he removes everyone or that he just removes those who may have, some entitlement to removal, the law is a little unclear on how that works in a criminal case.
But you can see what happened. No matter how he rules, if let's say he says that some aspects of the case stay behind with us here in Fulton County, and the 11th Circuit changes their mind and reverses that entirely and says, no, the entire case has to get removed to federal court. Where does that leave us in the middle of a jury trial? Is double jeopardy attached? Have you now risked your entire prosecution because this case has now been removed to federal court and we've sworn in a jury and it's been presenting evidence against all these other co-defendants?
Judge, again, I think for those very complex kind of fine-tuned details, we may need the opportunity to brief those issues.
It's not easy. And we've got, again, less than 2 months to figure this out. So I think to kind of charge ahead without coming to some thoughts on this very soon might be risky. So, and then the other issue here is even if we say that the 3 prongs aren't met, again, just dealing with the logistical issues, the state's case may take 4 months, but voir dire with 19 defense attorneys is going to be a different animal than voir dire with 2. So I don't think saying they're both going to equally be 4 months, no matter how many defendants are involved, would be completely accurate. Is that fair? In terms of who can object? Just at any particular question that's asked, the sidebars that are requested, just the sheer physical limitations if one attorney gets sick. Is it really so? Can we so confidently say that each trial is going to be exactly 4 months, no matter who's involved?
I don't think we can say exactly, but I think it kind of cuts both ways, Judge, because if we had, for example, 19 people tried at one time, you have a witness up and let's say they're subject to 19 cross-examinations. Of course, each of those 19 is not going to be the same full length cross-examination. So you would have kind of a shorter, if you took them all together, you might have a shorter time for that witness on the stand with 19 people versus if you have 19 trials of one person. And I'm going to the extremes just to demonstrate the point. But if you have 19 trials with one defendant each, then each of those witnesses would be fully cross-examined 19 times. So there's a give and a take. Some things might take longer, some things would be quicker.
So the other things to think in mind is this is going to be a case with a lot of pretrial motions. And again, I don't know how many hearings we're going to need to have to sort through all those. But if we compress our timeline to 40-something days, our ability to even be able to really weigh those and think through these issues, again, it just seems a bit unrealistic to think that we can handle all 19 in 40-something days. That's my initial reaction. Thinking of just how to get this, and are we even delaying the inevitable? If we say there's no severance, aren't we going to have 17 defense attorneys get up here and file motions for a continuance just saying they're not ready? I think we've already had some counsel indicating they're on trial in other cases in federal court. And if we're just going to be sitting in a position where we're having to consider a continuance motion in 40 days, why delay the inevitable?
Sure, Judge. State's position on that is that we're here on two defendants. And so at this juncture, other defendants have filed their motions for severance and they may raise those issues. And it would be appropriate for the court to consider all of these issues in making its decision. But for today's purposes, we're here on two defendants. And the issue is, do we pull these two defendants out? Not do we pull, defendant 13 out or whatever the case may be. So the state's position is until those are raised by those parties, once we have hearings on those, that they shouldn't affect the court's decision as it relates to these two defendants.
Okay, so at a minimum, I think what I'm hearing here is that it might be appropriate at this time to consider whether Mr. Chesebro and Ms. Powell proceed alone together.
Whether they have provided the court and met their burden to show that they should come out. Not that the other 17 should come out, but they should come out of the pot is the state's position.
Okay. All right. Sure.
Like 2 minutes to respond.
Sure. Last word from the defense, since it's your motion.
So, Judge, I will take this down.
Your Honor, I'm not trying to oversimplify this because it is a complicated case, both factually and procedurally. However, as to the 19, Your Honor, there can't be a trial of 19 people, and it has nothing to do with the length of time. It has to do with the fact that two defendants exercised their statutory right to a speedy trial, and 17 other defendants, many of whom's lawyers are here, didn't. And that's our right to do, and that's their right to do. So with all due respect, Your Honor, I don't even know that there's truly a reason to spend much time. Of course, I can answer any questions, but really much time talking about 19. So really, I think the question here today, to wrap up, is whether it's a trial of State versus Powell and Chesebro or two trials, one State v. Chesebro, one State v. Powell. All of the cases, and we would like an opportunity, since there will be some post-hearing briefing, to read those cases the court State cited and maybe respond to them. I looked at one. It's the one that says, where there is sufficient evidence of a common scheme or plan to commit a criminal offense, joinder is authorized. Willingham v. State. Joinder is authorized. That doesn't mean that severance is inappropriate. Those are not the same thing. Just because joinder is authorized does not mean the court shouldn't sever. Let me be clear about something, Your Honor.
100%.
The state wants this case, and I think it's absolutely clear in the pleadings. The state wants a case against Donald Trump and all these people together. The state wants to make this case about Donald Trump. Donald Trump is one of 19 defendants. Ken Chesebro is another one. Ken Chesebro is not a politician. Before 6-7 months ago, he was probably unknown to 99.9999% of the population. You get all those nines? And so now to force him to sit here in a trial where there's evidence of all these other things is just not fair. And I'm sorry, Your Honor. They have a slide here. RICO is different. Sure, it's different. I acknowledge that in my opening. But what this slide does not say is that RICO overrides the rules governing fundamental fairness, constitutional and statutory protection that are designed to protect defendants. This Willingham case, and upon information and belief, I believe most of the other cases cited by the government are cases like murder. The Willingham case is a murder case. It's a murder conspiracy case. Certainly, the state understands the difference between 3 and 4 people being charged with one single conspiracy versus 19 people being charged with 3 or 4 different conspiracies. And Your Honor, if the court were to take the state's arguments at face value, there would almost never, if ever, be a RICO case that can ever be severed. And think about what that means. It means that the state of Georgia and the various district attorneys throughout the state can use the RICO statute, can take 3, 4, 5, 6, 7 different conspiracies, and at their sole discretion, with no oversight by any court, say that they're one, bring them in one indictment, and then we're all stuck together. And quite frankly, Your Honor, let's compare and contrast this to the YSL case going down a few, I don't know if it's floors down or up, I think down.
Good.
That YSL case, I don't know much about it, but I know enough. I've watched it TV, listened to podcasts. It's a common conspiracy. Yeah, there were different overt acts being done towards the same conspiracy, and therefore the state can try them together, but it's one conspiracy. And that's where I think if you read that Willingham case, where there is sufficient evidence of a common scheme or plan, how, Your Honor, is the plan down in Coffee County, if it's a plan, the alleged plan, have any commonality other than electing Donald Trump, Your Honor? Half of the United States took some act towards electing Donald Trump. If that were the only thing that mattered in terms of connecting all these as a common conspiracy, there would be no rules of due process. And the last thing I'll say, Your Honor, is I will go back to what we said at the beginning. I think it's perfectly clear here that this trial does not have to last 4 months. Because what the state is assuming is that, let's say Your Honor grants our severance motion and allows us to try our case just Chesebro and then Powell separately. Well, they're saying, well, it's all going to be the same evidence. Not necessarily. Obviously, the time hasn't come to file motions in limine, but we will obviously file motions in limine regarding the admissibility of certain evidence, certain extrinsic evidence of other acts that we don't think are relevant. And we have the other motion to sever the counts. And no one motion, I don't think, Your Honor, should be, they all, obviously, I know the court has to rule on all of them independently, but I would argue, Judge, that you should consider them jointly in terms of figuring out the big picture here, which is, it is within the court's control to.
Well, let me clarify something, because I think the argument of the motion to sever the counts really wasn't so much as a ruling on
Yes, Your Honor.
limiting the evidence, just as a logistical, here's the indictment we're going to hand the jury.
And I meant altogether. So if you combine, let's say Your Honor was to grant that, it would be a significantly pared down indictment. Then, assuming that we're going to file motions in limine that kind of track the same type of arguments, right? The things that I know Your Honor is not going to rule on this until we file it, but you might expect that if Your Honor grants a motion that says, all right, these 50 things in the indictment don't get read to the jury, it's probably a pretty good chance either way that we're also going to file a motions in limine to say that evidence of those things that have nothing to do with Mr. Chesebro also can't come in. Your Honor, the bottom line is the state cannot be allowed to call something RICO and the rules are out the window. It wasn't what the General Assembly intended. It's not consistent with just basic principles of due process and fundamental fairness. With that, Your Honor, unless the court has any questions, we appreciate it. And I reserve the remainder of my time to the extent there is any.
Mr. Rafferty?
We've beaten the dead horse as it relates to your discretion about granting a severance between Mr. Chesebro and Ms. Powell. But the first point I made, I think, remains, and that is Ms. Powell has filed a demand for a speedy trial, much in the same way as Mr. Chesebro. Many of the defendants, as counsel has indicated in the courtroom here today, their lawyers have filed motions to sever. And I don't think any of the case law or anything that the government has cited here today trumps my client's right to a speedy trial. She has asked for a speedy trial. She filed it timely, just like Mr. Chesebro. Therefore, I think at a minimum, her case is severed from the remaining 17. It must be severed because none of the cases that the government cited point to the idea that all of those considerations trump the statutory rights of my client to a speedy trial. So, we can see what post-briefing comes in about severing Mr. Chesebro from Ms. Powell, but I don't think there's any dispute at this point that Ms. Powell and Mr. Chesebro are severed from the remaining 17 based on our demands for speedy trial.
All right. Thank you, Mr. Rafferty.
Your Honor, just briefly, just for the purpose of the record, I want to make clear that there is a dispute about severing the 2 from the 17. I think the state's made that clear, so I just want to make sure that that's cleared up for the record. There's some statement. And just before we depart, we would just ask for if there is briefing, what that briefing schedule is.
Of course. No, I think we still have plenty to talk about before we wrap up for today. So obviously, I think as has been made clear, we're on an expedited timeline with these statutory speedy trial demands. And we are certainly here ready and willing to provide both defendants that right. And we plan to make that October 23rd trial date stick. With that in mind, I don't know if we're always going to be able to have the luxury of pre-hearing briefing and post-hearing briefing. And some of these issues may require a little more exploration than others. This one, I don't think is one of those. When it comes to the question of whether to sever Ms. Powell and Mr. Chesebro, I certainly agree that there are always guardrails and that RICO as indicted can't just be used to do anything, but it is broadly construed, and those guardrails are found in those 3 factors. And the 3 factors traditionally that we've gone through really don't seem to be at play here. We don't, for one, the antagonistic defense issue is conceded. Both parties are going to be claiming they have no idea who the other is and won't be pointing the fingers at each other. I think the argument that they're charged in 2 separate kind of silos of charges strengthens the idea that there won't be confusion amongst the jurors and there won't be spillover evidence. So really the strongest thing that I'm hearing, and I don't think it's invalid, is that it's going to be kind of a matter of inconvenience and potential added expense to have both defendants sit together. And that's certainly true, but there's also other judicial economy aspects to consider and issues of inconvenience as well. We talk about the jurors. I don't think we can take for granted that these would both be 2 equally 4-month-long trials. I think it could easily be twice that with multiple defendants, and I think we need to take into account the fact that one docket goes entirely on hold while this case is going. And instead of it being, if we're purely considering aspects of judicial economy, which to me was really the only valid argument here, I think taking up 2 dockets and for a period of 4 months also weighs into that, as well as the voir dire process and the inconvenience to the jurors. So based on what's been presented today, I'm not finding the severance from Mr. Chesebro or Powell is necessary to achieve a fair determination of the guilt or innocence for either defendant in this case. And so I'll deny Mr. Chesebro's motion to sever from Ms. Powell. I'll deny in part Ms. Powell's motion to sever from Mr. Chesebro. And the plan will be to enter a scheduling order for Ms. Powell mirroring that of Mr. Chesebro with the October 23rd date holding. It sounds like the state is still sticking to the position that all these defendants should remain, and they want to address some of these removal issues. I'm willing to hear that. I remain very skeptical, but we can. I'm willing to hear what you have to say on it. And so, but again, because we're on a limited time frame, I don't think we have the luxury of waiting. So how long do you think the state needs to respond to that issue?
2 weeks, Judge?
I don't think we can do that. There's going to be motions deadlines for the other defendants, and we need to get scheduling orders entered.
Had to ask.
That's fine. And I had to deny.
Understood. 10 days?
Well, I think the 10-day mark from today. I know, I'm setting the indicator that folks are going to have more than 10 days to file their standard post-arraignment motions. Let's see if we can have that by Tuesday of next week. Again, this is limited to how you think logistically we could possibly keep these defendants together. And I think we can limit that to 10 pages. And if anyone else wants to respond, they can to that issue. But Mr. Grubman?
Yes, Your Honor. This is, if you're still going on this issue, I did have a quick other issue just since we have your attention to bring up. We do have a pending motion to talk to the grand jurors.
Right. Let me get to that. So again, knowing that Mr. Chesebro and Ms. Powell are hurtling forward and the motions are going to keep coming in, I don't think it makes sense to just have these all pile up. So we would pretty much maybe just keep having these weekly sessions together and handle them one at a time. So to that end, I believe we're starting another trial next week. I think it's a murder trial we're doing next week, but looking at Thursday or Friday of next week, how's everyone's availability? I only saw motions from Mr. Chesebro, so I guess the question's only directed towards Mr. Grubman and Mr. Aurora. I'm looking at Thursday or Friday morning.
We're here whenever the court instructs us to be.
Got it.
Your Honor, could we, for Friday morning, I'm going to do a sentencing.
On Thursday morning?
Yeah.
Thursday afternoon?
You know, Florida State Howard is going to be free, so I just figured we could have, depending on the motion, just.
Well, so far you've got, I believe it's the two related to the grand jury, and then you have one more related to the supremacy clause.
We've got 2 more coming either today or tomorrow.
Maybe we limit it since the grand jury issue is something that might take more time to flesh out if it's granted. Maybe we limit it to those 2 for next week, and we can save the constitutional arguments for another day. Can we still do that Thursday morning though? Assuming if it's just those 2 related to the grand jury. That's the plan. Yeah.
I'm sorry, I'm John.
Sure.
Thursday morning or Friday morning?
Thursday morning, it sounds like everyone, and we'll do those 2 grand jury motions. And then Mr. Rafferty, if you want to jump on board and adopt them, we can obviously work you in.
Yes, just quick clarification. The briefing from the state by Tuesday, is that going to be on the question of whether it's going to be a trial of 19 or a trial of 2?
That's right.
Thank you.
Nothing else from Mr. Chesebro this time, Your Honor.
Okay. Thank you, Mr. Grubman. Anything else we should address since we're all here together?
Real quickly,
Sir, yes, sir.
some of the lawyers for some of those other defendants are in the courtroom may well have an interest in the issues and the arguments that the government makes about whether it's a trial of 19 versus a trial of 2. So are those other lawyers permitted to submit some kind of briefing in response to whatever the government says?
I think that would be fine. I think some already have. I think folks have already been submitting severance motions saying that they're not ready, that there are conflicts. And so, that might very well suffice. But certainly I'm not going to foreclose that opportunity if they want to be heard in more detail. So we'll send out an email to everyone indicating as much.
And relatedly then, on Thursday morning, we potentially have some discussion of that motion as well, that briefing?
We can. Again, I think by then I'm hoping to have already ruled and issued some scheduling orders because we need to get that clarity so we can focus on what lies ahead. Anything else?
No, Your Honor.
Okay. Anything from the state?
No, Judge.
All right. Thank you all. See you next week.
Thank you, Judge.
That was the Kenneth Chesebro and Sidney Powell severance hearing. If you guys were not seeing that, everybody here, thank you for stopping by. 491 people. Please give me a like if you enjoyed that. So both those people are listed as co-defendants in the big RICO case. Now they're making so what happens? Sorry, guys, there was a little bit of delay there. What happens with this from here? They are both seeking to they're both seeking to try their cases separately. Why? They're claiming there's going to be too much prejudice. There are 160 acts that are alleged. I only did 2 or 3 of them. And their argument is this isn't fair to them. They have the right also to a speedy trial, and they want to go forward. They want to go ahead. And doing this is going to go forward. So that's the issue. Now, it sounds like as of right now, the judge is not inclined to grant their motions. It sounds like the judge is inclined to want to keep this all together because for some reason, the state thinks they need to prove the entire conspiracy for both trials, which in this case, they're claiming would take them about 4 months minimum. I know they're saying 4 months. They said 4 months, 150 witnesses. I don't know how you could do 150 witnesses, even if you had 4 months of trial. That is a lot of people. And remember, you can only do so much during a day. And to have a jury sit there, you're not going to be able to get that jury for 4 months straight every single day, Monday to Friday. Everybody there would lose their jobs. It's just number one. Number two, people need to work to survive. So that's not going to happen. You'll only get the jurors a couple days a week. And that's after you've picked them. That's going to be months on its own. So there are a lot of problems. And the courtroom's hideous. Yeah, well, what can you say? So right now, the state has presented there are no real pressing issues. The idea of antagonistic defenses, where if Powell and Chesebro were both pointing at each other saying like, he did it, no, he did it, that would be an antagonistic defense. Right now, that doesn't appear to be the case. And I think the state does have the argument right now, but the state was also using RICO cases that involve gangbangers and drug dealers. This is an entirely different setup. But I will give credit to, I think it was Sidney Powell's attorney who brought up the really good point. There's a RICO trial going on right now, and everybody's implicated in the entire thing, and it's a lot more simplified, and it has turned into a disaster. And because it's a disaster, that affects your right to a fair trial. So I think there is a lot going forward that can help Powell and Chesebro, but for right now, I don't think it's in their favor. That doesn't mean that if they brief this, they can't change the judge's mind. But for right now, it's probably not going to happen. Looks like they're going to force everybody to go together. And we're still set for that October trial, which I don't see how that can happen. But remember, Georgia has a really fucked up rule with discovery. In Georgia, they can give you discovery 10 days before trial, and it's legal. Basically, 10 days before trial, they could take that whole stack of papers and go bloop, thud right on the table. And you know what? That's legal in Georgia. So there is a big problem. You guys are worried about the gold fringe on the flags. Okay, no. Now, was this judge being corrupt? No, I don't think so far. The state presented better law-based arguments, but it's because the law's on their side. And basically every time RICO's happened, they've allowed it to keep going forward, which that's just the way it works. Now, this is a unique situation, and that was something where the judge said, well, do you have anything on point? No, Judge, there's literally nothing this is a brand new situation. Like, how would anybody know a way to deal with this? This is literally a case of first impression. This is a novel situation. So I don't think it's fair to rely on answers that are out there like that. Chester Frost says the judge is being autistic. No, the judge is asking the hard questions because he has to. But I think he's I think he's shying away from the fact that he may have to do a lot of work. I think he is taking a bit of a pussy way out. I'm hoping he's not, but we'll see what happens going forward. This should have already been thrown out. Yeah. I do think the state's idea that they're going to try this case anyway, and the idea of we'll just hold out and see what the federal courts say and hope it works out in our favor is absolutely mind-boggling that they would even try that or think that's an acceptable outcome. You know, Your Honor, we're just going to see what the federal court says, but in the meantime, we're going to convict the guy, and we'll just take our chances. That is pure insanity to me. Pure insanity. And the fact those prosecutors said that with a straight face should scare you when you deal with a prosecutor. Because some of them are absolute loons. I mean, that's all you can say about them. That is all you can say about them. I just don't get it. Debbie O for $5. Thank you, Debbie. I appreciate it. I appreciate the support. Saying, seemed like the judge is willing to separate Powell and Chesebro from the other 17, but not from each other. Is that your take? I'm confused. It sounds like that might be an option the judge would do, but I'm still not sure. I still think he's leaning toward right now. He denied it as of right now, he's indicated he's not going to go along with it. He hasn't flat out denied it, but he's going to let everybody brief it, but he does not appear to be inclined to go along with it. Do I think this would help them if they could go together? Sure. But for right now, it doesn't look like that's going to be happening for either. Excuse me. It doesn't look like that's happening for either. For both of them, it looks like they're going to have to go with the whole group, which, holy cow, that is going to be a disaster and a half. Although it sounds like from the judge commenting on this, they're going to come back every week to discuss things. And if I'm available for those, we'll definitely have those hearings. So it will be interesting. So let's see what else you guys are talking about here. It's a whole bunch of grounds. Yeah. Agbao Chemist says the judge better request a bigger courtroom. LOL. Yeah, I think so. I mean, that's a separate matter there, but that's why he's going to allow cameras. It cuts down on having to do that. Eliza Grogan for $10 sent a super sticker. Thank you, Eliza. I appreciate it. Amanda Coelho or Colo, or I'm sorry, I butchered that. Saying, thank you for pointing out the difference between authorized and required. And if you guys heard about that, her the attorneys at the end also pointed that out. Removal can be done. You know, you don't have to keep them together. You can split them up if you want. It's at the judge's discretion. Barton Pell is saying, did Antifa recently get charged under RICO? Yes, by the state attorney general. He did RICO in a similar way. Similarly, it's a pretty garbage way they put it together. So, Doug Shannon for $5. Thank you, Doug. Or Douglas. Looks like you tried to say something or send a sticker. It didn't come through. You're saying, and again for $5, thank you very much, saying, how is trying the person but holding the verdict not a violation of due process? Oh, I agree. I've never heard of that happening. I don't think that's legal in the slightest bit. But remember, you're dealing with prosecutors. They don't care. They think everything is legal. Why? Well, Judge, because you didn't say we couldn't do it. And that's how prosecutors work, believe it or not. That's how they work a lot of times. Well, you didn't say we couldn't do it. Captain Bipto saying cameras add 10 seats to the courtroom. Funny. Fair Frozen 55 for $2 saying, hey Sean, how's that Liberty Safe shitstorm? Hey, yeah, we're gonna cover that on Thursday. By the way, guys, if you're new, my name's Sean, also known as Potentially Criminal. I am a defense attorney out of the Cleveland, Ohio area, and every Thursday night we do a live stream. We generally talk about topics that are going on in the law, and we address the things that are happening there. Also, if we have a chance something like this pops up, I was just working and somebody, the lovely future Mrs. Martin told me there was a hearing going on, so we jumped right in and right at the lunch break and went forward. So yeah, I think it was good timing there to get in on it. But yes, every Thursday night at 9:30. So tomorrow night at 9:30, we'll be going over this. We'll be going over some other things that are going on. For example, there's already a couple of really good issues already to talk about. Things are going on in the Alex Murdaugh case. There's a big ruling regarding 18-year-olds buying handguns, Liberty safes, kind of selling out to the FBI, the Takaya Young shooting that happened in Columbus. Then also just some other really weird things that kind of make you go, oh, But we'll be talking about those tomorrow night. Benjamin saying we can hold the trial at State Farm Arena. That's very much like the trial of Charles I, holding it in an arena almost. Cale Burke says, isn't that what they're going to try to do, Meadows? Hold the verdict till the feds decide? Yeah, but I don't think they can do that. That is not legal in any way. Basically, having the verdict just sit out there. Because what do? You're going to have the jury decide the verdict. You can't just leave it and then if it gets all denied, you bring the jury in and then they come and decide the verdict. No, you're going to have them do the verdict, but it's going to have to sit there on the clerk's desk for months on end, maybe years on end. I don't see how that's legal. You're saying, do all 19 attorneys have to get to work together and then a main representative lawyer? No, because remember, they all may have different objectives because they're not all exposed to the same levels of culpability. So they may, there might be times where that's possible, but generally speaking, when there's for a witness going up, there's going to be 19 cross-examinations. You have the right to confront your accuser. So every single person gets to confront that witness. That is just how it goes. If there are suppressions, each person has the right to file their own motions in limine. So having a specific attorney representative isn't really going to work. Lucential says, yeah, you couldn't even release a jury technically. Yeah, I don't know how they would handle this. Chaucer saying that is wild. 19 different lawyers launching 19 different objections. Yeah, because in some situations it's hearsay. Some situations there's foundational issues. Sometimes it's going to be a 404 prior bad acts issue. There's a lot of different ways this can go. Yes, this is going to be a dumpster fire if it actually happens. That dog, and I'm saying the judge elected to do it this way. Yeah, I that's, I don't know. The whole thing just doesn't sit well with me. Also, let's see here. Okay, so let's, and you guys were wondering about the judge. We'll look him up real quick here. Ag is saying, have they set the Young Thug jury yet? Nope, 6 months in, still no jury. So Judge Scott F. McAfee. So he was the Georgia Inspector General. He served as an assistant district attorney and an assistant U.S. attorney. Okay. So it looks like he was appointed by Governor Kemp. It was just recently sworn in. Jeez, I mean, it's like the one down below. It's like the one in Florida, fairly new, and she gets the Trump case, and this guy gets a Trump case too. He's running for a state term in May 2024. Where is? Let's see. Okay, so he's on the right. Let's say he's conservative. Who knows what that really means, though? I don't think it's clear what that means. Yep, he's a very new judge. Harris saying, do you think the tactic of draining the government so much paperwork they give up, do you think it could work? It's really hard to do that as a defense attorney because generally you don't have resources like the government. The government could just give you like a tsunami of paperwork, but it's really hard to do it from the other side. Now, in a civil case, that's different, but in a criminal case, you generally don't have extra things to give. So I would argue that's the difference. And when you're trying to deal with the defense, or the prosecutor, you generally just want to give them the thing and like, look, so you can almost shake them and say, look, you idiot. Look at the evidence. Like, listen to me. You generally don't want them to. The Jackals of Terra Argentum. Thank you. Thank you for becoming a new member. I appreciate it. I appreciate the support. Axelmood saying, how's the brand new judge being assigned? It just happens. You assign the judge. Things happen, man. You know, I don't think overall this is going to be bad for him. It's going to be better than having some shrill harpy, I bet. So the Jackals is saying for $5, thank you, by the way, is saying he seems as conservative as Irving Kristol, which if you guys don't know that's Bill Kristol, the commentator, the Rhino commentator. His dad, Irving Kristol, is the founder of the one of the founding fathers of the neoconservative movement, which was basically disaffected Marxists who weren't cool enough to hang out with the commies. So they started their own club. Anthony's saying, doesn't this violate the Constitution since presidents can't be charged when it comes to what happened during their presidency? Well, there's nothing saying he can't be charged. It's just the idea of like him getting sued and then, having service on him. Those are issues, things may have to wait till after his presidency. But it's not necessarily unconstitutional. Because, I mean, technically, getting impeached is being charged. And I am sorry, I don't know why I'm yawning like a boss today. This is just, Man, if you guys have any other questions, fire away here. Fair Frozen saying, did I see the cringe on the juror of the Murdaugh case? Yeah, we're going to cover that. That is absolute, bullshit. That if any of that happened. Now, whether that's going to result in overturning of a case or we're just going to get like, hashtag harmless error. It doesn't matter. He's guilty anyway. Lol. That's the good chance that's going to happen. Pam Harriman. Hello, Pam. Is saying too many rhinos. Yep. More rhinos than on a Swahili nature preserve. But yeah, so we are going to go through the allegations in the motion, but also we're also going to go through the affidavits because a couple of jurors wrote affidavits and then one of the paralegals wrote an affidavit about what they talked to one of the jurors with. Adam K saying impeachment's the only mechanism to remove a sitting president. Sure. And there are a lot of charges. They think he committed a crime. High crimes and misdemeanors. So, Yeah, nothing says it can't be held liable, and that's true. Allegan saying, how do you even get 19 lawyers and accused at the defense desk? There's going to have multiple, they would have to have multiple rows of defendants. I mean, it's just going to be it's going to be a mess. And yes, remember that courtroom's going to be a little tight, but you know, the state wanted this, so it's their job to partially get ready for it. So, give me and then have room for the public. Yeah, that's a second issue. And guys, I'll be right back. I have to go grab something. So give me 1 second here. And I will be right back. So hang tight. Be right back.
I know you don't smoke weed. I know this. But I'm gonna get you high today. Cause it's Friday, you ain't got no job, and you ain't got shit to do.
All right, guys, sorry about that. We're back. And Paul Carroll saying 19 defendants would be an agonizing trial. Yes. Oh, my God. The record for that case is just going to be, it's going to be like a phone book. That's just for like one day. Because remember, basically every attorney has to have a say. Yes, wise words from Chris Tucker. What else? So grabbing a claw, not yet. There's still work to be done today. Mr. Otterpocket says, who has jurisdiction for buying drone striking the Afghan family? Don't know. Just like what happened to Anwar al-Awlaki and his family. You know, U.S. citizens who were drone striked, although allegedly they got due process, which was Obama saying, well, hit them with the drone. And that was due process. Fair Frozen saying, does the government get to refute each 19 lawyers individually? Yeah, they're going to have to address each argument. Now, there's going to be times where they all make the same argument. And I think that's a very common thing. Hey, come here. Go back. Yes. So, yeah, it will be very interesting. Now, there's going to be times where a bunch of the attorneys are going to be like, Your Honor, I agree with attorney so-and-so. I make the same argument. And you're allowed to do that. I'm allowed to, you know, me, Kurt, Nick, and Legal Vices are all sitting at a table with our clients, and Kurt makes an argument. Your Honor, I echo the same sentiments as attorney, you know, Kurt Mueller, or Mueller, however you pronounce it. You know, we agree, and I would just surmise it a little bit, and then, you know, sit down and say, same argument. So it can be the same way. We can echo each other's arguments. Or I might say, Your Honor, you know what? I understand he's saying X, Y, and Z, but in reality, I think it's like A, B, C. I think it's 1, 2, 3. You and me. Yes. Trenton's saying, you know, you should argue something different on top of it, saying, just add on at the end, but I also have something else that's different. That would be great. That would be great. Yeah, Waco's saying, nice dog. Yeah, this is Clyde, if you guys haven't seen him before. He is, we've got a thunderstorm, and he is not liking it. It's okay, Bubba. It's okay, Clyde Bear. You're okay, buddy. I know you don't like the storms. You're so big and scary out there. It's okay, Bubba. It's okay. Just don't poop on me. Brooks is saying, so even the lawyers win because it's a separate circle of hell. Yes. Yes, but remember, that's going to be helpful for these attorneys too, because for this RICO case, this is all you're doing. Really. Your entire schedule, like you've got no other things going on. This is it. You went down, buddy? You went down? Okay. All right, I'm going to put you down. You're okay, buddy. Is the dog name for C.S. Lewis? No, that is the name he had when we found him at the APL. He is a shelter dog that we rescued. So I don't know why they named him Clyde. But Clyde. Charlie's saying, will this all be televised? Looks like it for the most part. Is it thunderstorming? Yes, you can hear it a little bit. I opened the window because this is nice out. The Jackals of Terra Argentum for $10. Thank you, sir. I appreciate it. The due process for that was Barry Sotoro seeking approval from his husband, Big Mike. Actually, Big Mike, who took time away from battering their test tube babies to approve that strike. Yes. Darcy's saying the lawyers are fine in the YSL RICO case, so they ask the same questions. Well, to be fair, all the attorneys in the YSL case, even the prosecutors, have been playing games and getting in trouble doing a lot of dumb shit. So I think it's going to be a little different, especially in a case like this and high profile it is. I don't think that's going to fly now. Because I think that's unconstitutional to. I mean, during voir dire, maybe they can get away with that. But during the actual case in chief, you're basically denying somebody their Sixth Amendment right. Like, each attorney has the right to ask questions. You know, the state and the court wanted to try it all together. So, hey, judge, that's your problem. And that's the way I would make the argument. I don't think legally they can make that stick. But we'll see. We will see. A dog at the ADL? No, the APL. Someone saying the Anti-Puppy League? No. The Animal Protective League. Somebody had dropped them off. It was a really sad story. He had only been dropped off when we found him. It was like April 10th, and he had been dropped off April 5th. So he'd only been there like 5 days. And then by the 15th, we were able to adopt him and pick him up. So, you know, it was nice. He only had to spend 10 days in there, but still kind of sad. Paul saying, is the jury even going to remember opening argument 1 when they were on opening argument 17? Yeah, I don't know how this is going to work. The logistics of this are going to be a disaster. I mean, I'm probably not going to air the opening arguments. Why would I stream them? If I'm going to stream them, I'm going to stream them and just sit here and play like Battle Bit or something in the meantime, because there's no reason to listen to them. Everybody's brains are going to turn into mush. 17 or 19, well, actually, it's going to be 20. 20 opening arguments. The state gets 1, and then each defendant. That is, and for a massive case like this, I could see each one of these taking an hour. 20 hours worth of opening arguments. Just paint the freaking wall with the inside of my skull. But yes, I will be trying to stream the trial as much as possible. But I don't think it's going to happen in October. There's no way I see that happening. I just don't see it. And then, Jackals, I just wanted to also say thank you for your super chat if I didn't already say that. Thank you very much. Ashton says, I'm an hour behind. The state is so disgusting. Yeah, yes, I think they're very disgusting here. Wombat Mommy says, are they even going to get through cross with so many lawyers? Yeah, and that's the thing. With 19 lawyers going after you, you're going to fuck up on the stand. And immediately, like, let's say the testimony shifts during cross-examination. And by lawyer 17, things are coming out differently. I mean, the first guy who went up and did cross is going to say, Your Honor, this is like, the testimony's different now. What do we do? He's going to have the right to like reconfront this witness. Like, we're going to have recross almost. I mean, it's just going to be a train wreck, an absolute train wreck. Lunatic Bro says, would the state get 1 rebuttal or 19? I think it would work as this for closing arguments if you're saying it, because the state has a burden of proof, they get the final word. So generally you have the defense goes first, the prosecutor second, prosecutor first, defense second, then the prosecutor again for the rebuttal, and they get the finish off before it goes to a jury. I think in this case, you would have the prosecutor goes first, and then all 19 closing arguments, and then a rebuttal. I don't see how else you could do that, because if they rebutted each, I mean, and having to rebut 19 arguments at once, that's going to be really hard to do. That's just not going to end well. So I just don't see how that works for everybody here. Will the state get 19 hours worth of opening to address each defendant? I don't know. I don't know how that's going to work. I mean, let's say they just get, I just threw out the hour as an example of, think about it, an hour is 20 hours worth of this. So you're going to have like 4 or 5 days of opening arguments. But yes, the state's argument is probably going to be a little longer because they've got it's 19 on 1. But remember, it's their fault they chose this. So the judge may give them like, okay, you can get 2 hours of openings, but he's not going to give them 19 to equal out. Charlie's saying, will the jury know the abyss they're getting dragged into? Yeah, they're going to find out they're in the Trump case. Imagine them trying to take notes. This judge might not let you take notes. Remember, that is up to each judge. So that judge could say, hey, I'm not going to let you take notes. The trial I just had last week, jurors were not allowed to take notes. Some judges think, well, if they're focused on their notes, they're not paying attention. And then when they go in the back, they rely on their notes as though it's the word of God. So there might not be notes. Think about that. 4 months of cases, and you're 4 months of a case. And that's presuming the state's going to be right about whether that's going to happen. 4 months. You got to remember every goddamn thing. Not happening. Not happening. So let's see here. Paul is saying, Paul Carroll saying, by the way, hello, Paul. I need to reach out to you because I think we have a mutual colleague now. OJ's jury is the longest sequestered jury in history, 265 days. I wonder if any of these Trump cases will beat that. This could very well beat it. But I mean, I'm not going to lie. If I was in a jury for that long, I'd be filing a habeas corpus petition. Like this is almost detention. This is almost unlawful detention at that point. Sullivan saying 150 witnesses, 19 lawyers. Is the 150 only the prosecution's witnesses? Yeah. That is the prosecution's witness list alone. They said 150 witnesses. Now, maybe they'll be able to parse that down, but right now they're saying they have 150. Principal Potatoes saying, question. If they allow 2 to have a speedy trial, will the outcomes of those trials be brought into the other 17? No, and I don't see how they'd be able to bring them in because the prosecutor doesn't get to say, aha, Sidney Powell was found guilty, therefore Trump is guilty. Therefore John Eastman's guilty. Therefore Jenna Ellis is guilty. They're all guilty. No, they can't do that. But they could say, hey, Sidney, look, I know you just got convicted. If you come and testify, we'll make a sentencing recommendation for you. Just saying, girlfriend. I mean, that could happen that way. Randall says, not your there. I see what you're saying. They're treating this just like they caught a bunch of drug dealers together. They don't know other tactics. Yes, this is all they know. When you have a hammer, everything becomes a nail. Kelly R for $5. Thank you, Kelly. is saying any truth about Fanny being conflicted out with her own legal issues, or is that social media BS? For right now, it's all social media BS. And yeah, she said things in 2020. Don't count on any of that till you see her actually leaving the courtroom or her office leaving this alone. Adam Case is, what happens if the prosecution calls defendant 5 as a witness against defendant 12? Do they get to plead the 5th? Well, you don't call the other defendants. You're going to try to call them, and that's a problem. That's an issue already, because these guys, that would have to be provided in notice that these parties are going to be testifying. And so far, none of that's been provided. I don't think any of that's happening so far. So that would become an issue. But yeah, people could plead the 5th. But you're just saying, like, if they're all sitting there, and if I'm the prosecutor, I could go, I'm going to call Sidney Powell now. It doesn't work that way. It's just like if you're sitting there at trial with just one defendant and you go, I want Mike the meth head to take the stand. You can't do that. There's a presumption of the right to remain silent that you would invoke. It won't go that way. Now, if one of them decides to cooperate, that's a whole nother issue. But that also becomes, you also have issues about, there's a lot of confrontation issues there. There's going to be a lot of confrontation clause issues under the 6th Amendment. Paul Carroll's right here. Direct examination, then, then cross, then redirected. Finally, recross. Yeah. It could take a week to get through a single witness. And Elijah's saying, and you cannot ask the jury who they voted for. I think they could. I think they very well could. But for right now, I don't know how that would. You'd have the right to inquire. I just don't know how that would go. Fair Frozen says 4 years sequestered. Imagine. That would be horrible. Nosur San saying, how would they even get enough jurors to accept $20 a day and pay for 4 months? That's going to be an issue, because a lot of these jurors are going to be like, look, I got to pay my mortgage. And here's the thing. They probably won't have the jury every single day. But, that becomes a problem, because they're probably going to want them sequestered. Well, these people have to go home and work and do shit. Yeah, this is, problem on problem on problem on problem on problem on problem on problem. There are so many problems here. Aaron Gogol saying Chauvin trial established you can lie your way onto a jury. That's always been a risk. It's just never been a problem, because generally there's been no political motivations for people. With these politicized trials, that becomes a problem. Now, in this case, especially, the more moneyed parties involved are going to do that research that Robert Barnes always talks about. Especially if they try them all together. Trump, his team alone, they are going to do the data research. They are going to dig through every single juror pool, Facebook, Instagram, Snapchat, MySpace, everything you've ever done or said. They are going to roto-root your history. So I don't think that's going to be an issue, because Trump's team will have done that, and all that will be applicable to every juror. And every defendant could get it. Randall says, will they be able to find 12 black trans lesbians for the jury, though? I don't know. Well, they got to be post-op trans, too. My Dumb Movie says, I've heard that they're in federal district court, does the jury pay better than it pays better, but remember, you're still not going to be able to provide for your family on this. Parallax says, how much are you lying to get out of the jury duty? Well, I'm an attorney, so they're already going to tell me, bye. There's going to be they're not going to waste any time on that. Let's see here, you guys. Judges said all the polling has to be done with her approval. I think Trump should do it anyway. What polling? I'm not sure what you're getting at here. I'm sliding around. If Jenna pleads again, can she be disbarred? Well, if you plead guilty to a felony or anything that questions your character or fitness, or it's a crime of honesty, you're always subject to reprimand and disbarment or suspension of your license. Walter Malone. Hello, Walter. It's good to see you. Saying maybe they'll do the jury via Zoom. Don't give them ideas. Don't give them ideas. Harris Riley says in Alabama, employers are obligated to pay you for your time on jury. Maybe, but I mean, you know what your employer's going to do? They're going to file a motion saying it's one thing for a couple of days, but for me to pay for you for 4 months straight would bankrupt me. I'd be making that motion in court saying that is a takings issue. That becomes a Fifth Amendment takings issue without due process. I have to pay for somebody for 4 months and I don't get any say in that. I think there would be people rebelling against that. Michael Stetson says they're going to ask if you watch any attorneys on YouTube, and if it's not lying, crime, or legal, you'll be dismissed. Sadly, very true. Wombat Mommy says, so no Coliseum, Sean, pretty much. Cheryl Torrey says, very hard to compare political monkey business with murder. It is. Muriel's is saying it ought to be a takings issue for each juror as well. Yeah, I'm sure, and if any of those jurors are smart, you're basically at least 4 months of your life is gone. Yes, that's going to become a takings issue. I'd argue it's multiple issues, and I think that would be hilarious. Your Honor, you show up in court, and I'm just thinking about how that would go. Get retained by a juror, show up and file a motion to intervene and say, a habeas corpus petition, and file it. Let's see what the court says. I'm immediately appealing this, Your Honor. Maybe I go straight to federal court with it. A federal habeas petition. I don't know. Fair Frozen saying for $2. Companies offer that as a benefit. Your corporation does. Yeah, but remember, ask your corporation if they pay you full pay for 175 days. See what they say at that point. I'm sure their answer is going to be, well, you're in Puerto Rico, so they wouldn't say what, but they'd be like, ¿qué? And they'd be like, no es bueno, no es bueno. Agbiochemist says legal seagull. Yeah, well, he's even cringier because he was on Philosophy Tube as a guest commentator, which even more cringy. Even more cringy. If you don't know who Philosophy Tube is, consider yourself lucky. Adam Case says, regarding picking jurors, does each defense attorney get a number of dismissals? Can you explain how that would work? I mean, typically, when you're by yourself, each defendant gets preparatory challenges, meaning I just don't like that juror. I got a bad feeling about him. I don't have to disclose the reason why I want to excuse him. Now, I can't do things clearly on racial grounds. So let's say there's 2 black jurors on the jury and I intentionally exclude them. That causes a problem because now you get into Batson v. Kentucky, where that becomes, as long as I can demonstrate the reasons, like I would have to explain those ones, because that becomes an issue of it appears that the court is being used to enforce racism, which is a violation of the 14th Amendment. But typically you're going to get a couple of preparatory challenges. But yeah, every defendant is the right to pick a jury. And yeah, how's that going to go when at some point, Sidney Powell and her attorney are like, I don't like jury 1. But Trump's sitting there like, yep, I like jury 1. And we go through the selection and Trump goes first. I'm fine with juror number 1. And you get Sidney Powell and she's like, I don't like him. And they get rid of that juror. I mean, I don't know how they're going to do this. 19 jurors. Let's say they each get 3 preparatory challenges apiece, which is kind of the standard. 19 times 3 plus the prosecution. They're going to get what? Just their 3? Are they going to get more? I mean, that's a lot of jurors to fight through. And yeah, let's say you get rid of one that I want. You know, the juror likes me. The juror likes Trump, but hates Sidney Powell. What do you do then? I mean, these guys this is going to be a fucking mess. A mess on mess on mess. That's an interesting thing to think about. And I'm like, I don't know how that's going to go. It's going to be a disaster. Yes. Yes. No lemon pledge. No more lemon pledge. Participation trophy wise says, if I get called for it, I'll be sure to call you just so you can looky-loo at it. Sure. I'll come down and if you get stuck on it, I'll come down. I'll get Pro Hoc Vice in and I'll talk to a lead attorney. He'll Pro Hoc Vice me and I'll come down and file a lawsuit and I'll get on TV. Amateur Iconoclast says, is that better or worse than BreadTube? No. The channel's Philosophy Tube. He's a BreadTuber. Fair Frozen 55 for $2 says his job will still say, what? You work for the military industrial complex. Okay. Lucential saying, let's not forget, how many jurors do you need to pick to ensure you have 12 at the end of 4 months? I don't know. I don't know in Georgia if you're entitled to a 12-person jury. It might be less. So that's an issue here. And hold on 1 second. Sorry about that. We're back. Yeah, how many jurors? I mean, I think you get 12 in Georgia, but that's not guaranteed. Remember, Florida, you get 6. So think about that. 19 people with 3. You're going to wipe out the jury a couple times over. They're going to be calling in thousands of jurors. I mean, remember, Young Thug was months of jury selection. We're going to have months of jury selection here. And think about how many alternates you're going to need on a case this big for this long. You're probably going to have 12 alternates. I think any less would be foolish because you can't get, like, in 4 months, having 12 random people, they're going to be deaths in families, all kinds of things. Zero Fuck saying base with the he. Yeah, well, Oliver is, Oliver. Jonathan saying, is RedTube porn for commies? No. Let's see here. Even for Shadow Knight saying, even for RICO, generally the amount of jurors you get is set by state law or your constitution. So it's regardless of the type of felony, except for capital murder. And I think at this point now, you pretty much have to have a 12-juror jury or a multi-judge panel. One Bet Mommy says, how are they going to start in October? I have no fucking idea. I don't know how you could. I don't know how you could start then. There's no way this works. I really don't see how this works. It's just it's not going to work. It will not work. There's just no way. I'm sure Fannie Willis is going to cry and say this is all racism or something awful. But yeah, it's not going to work. It just won't. You know, I don't see how they get it to work. So, yeah, it's going to be a disaster. That's what this is going to be. So, like I said, we're going to have to see though. And, maybe I'm wrong. Maybe I'm wrong. I've been wrong before. That's just how it goes. I mean, that's kind of what I do. Let's see here. See where you guys are at with this. What are we talking about anywhere else here? And some of you guys are wondering, oh, what about Paul? Yes, you're right. Judge, okay, all right, 12 jurors and 48 alternates ready. Yeah, you're going to have to do something. And pie case, you're right. What if COVID breaks out? I mean, in the middle of COVID, there was a capital murder case, a death penalty case going on in Akron, just south of Cleveland. And one of the jurors kind of had a cough and it freaked out one of the jurors in the jury box who was like really COVID scared and like COVID susceptible and said, I can't be in here. I won't come to court anymore until that juror is safe. And they had no more alternates because they had all gotten sick. Barton Bell is saying Trump should have issued a bunch of hidden pardons. You can't do it like that where it's just like everybody's got them in their pocket. Like those have to be publicly done. But I get what you're saying. Brooks is saying, are you ready for appeals arguments? Yeah, there's going to be a lot of those. And I hope those get televised because there's going to be a lot of interlocutory appeals. Yes, they're going to hire Todd Howard from Bethesda. Well, Attorney Howard, how does this work? Your Honor, it just works. Understandable. Guilty. Mystery Sniper says, am I still going live tonight? Wait, it's only Wednesday. I gotta fix I put together a shower. I had to reinstall it. We had to reinstall a shower fixture. Had to do a little bit of plumbing. Got a leak I gotta find first. So I gotta spend all afternoon getting that ready. I was gonna have to mow the yard. I was gonna mow my yard today, but now the thunderstorm, I'm not doing that. So yeah, I gotta work on some plumbing. As long as I can get that done, I might try to go on tonight. Michael Stetson says presidential pardons only apply to federal crimes anyway. Yeah, that's secondary issue, but you are correct as well. Michael Stetson saying, it's funny when Jack Smith mentioned the people's right to a speedy trial. At the federal level, it's called the Speedy Trial Act, and it does exist. It does not override the Sixth Amendment to the U.S. Constitution, but it does exist. And while I'm using the DOJ's website, it's accurate. You can look it up on Cornell Law, all that. So it's a Speedy Trial Act of 1974. So the trial must commence within 70 days from the date the information or indictment is filed or the date the defendant appears in court. Okay. But it's not just for the defendants. The state, the government has the right to, and there's a public consideration. The public has the right to trials that end in a reasonable conclusion. So I mean, it's not just for the government. It's not just for defendants. Now, the Sixth Amendment does override all of that. Sixth Amendment uber alles. But at the federal level, they can invoke, hey, the public has a consideration, so does the government. So just be careful. At the state level, no, it's all... There might be a Speedy Trial Act somewhere in some state, but I'm not aware of it. So... Job well done says shower valves are easy. Yeah, they are, but I have to find the leak, so I got to go back through and pull it all apart. So I found one leak, fixed it, and now there's another leak. So I'm just chasing leaks around right now. So it's not bad. I'm not Mario or Luigi. It takes me a little while to pull it all apart and get it fixed. Live plumbing stream, no, because there's a lot of swearing. 21 Gun and Done says, do all 19 lawyers get jury challenges? Yeah, I mean, they would have the right to. I mean, like they're all gonna have the right to challenge jurors for cause and for hardships and then peremptories. They would not be able to. Yeah, there's gonna be all kinds of jury questions. It's gonna be a mess. My movie says finding a leak. Yeah, can the feds help me out? You guys are good at finding leaks. Michael saying, "Oh yeah, I didn't know about that act." Yeah, it's just yeah, no worries. It's I mean, up until this case, nobody probably ever really heard of it. Paul saying, yeah, imagine the jury instructions for this. Oh my God. I mean, I had a rape trial last week, and the jury instructions were 17 typed pages. This thing is going to be, this judge is going to read a book to people. Mark Henderson says that the federal court grants a supremacy clause issue for the Mark Meadows case. Does that drag all the defendants in? I don't. There are talking heads that say yes and no. I don't know. I could see some of them, the judge saying yes to some, no to others. And then I can see those are people appealing, and that's going to cause even more delay. So, I mean, I don't think it's 100% clear. Michael Stetton saying, isn't the Sixth Amendment to prevent the state from definitely holding a defendant without due process? Yeah, it's your right to, your speedy trial rights. Your right to a speedy trial is there. I mean, and that's how you get, from without due process there. Chaucer saying, is the conspiracy they're being charged with, they question the election officials? There's more to it. If you guys read through it, they talk about going out to some of these counties, accessing voting machines. Now, it sounds like they had permission, but the state's claiming they didn't, that they may have intimidated people, all kinds of nonsense there. Yeah, I like Mario because I have the suspenders too. Yes, potentially plumber, yeah. Oh, you guys are asking about the governor doesn't have that power? Yes. The governor of Georgia does not have the outright power to pardon people. There is a pardon board. And the way it works in Georgia is you have to be convicted and serve your sentence. And then you can apply. So there is no way for this to go through and Brian Kemp goes, everybody's pardoned. Same way in Texas. Texas does not allow that. Now, it's funny because like here in Ohio, let's say the case was happening here in Ohio. Governor DeWine I hate the man. He can come in and say, yep, pardon, everybody's done, go home. And that's it. But states like Georgia, they have to go to the pardon board, and it's only after you've been convicted. Were you found not guilty? Funny. Mary Ricketts says murder out a jury of 12 and 3 of them didn't listen to instructions. Yes, that's the thing though. But there is case law pretty much in every state, in every federal court that says if you give a juror instructions, they presume that they listen to it. That's a bullshit argument. It's bullshit logic. But the presumption is if you tell the jury don't do X, they agree and they won't do X. Even though you know they do whatever they want. Jonathan says that Sean's the only BBW I need. Thanks, I guess. Bella says you have to serve your sentence. Yeah. But I mean, like if you're sentenced to 5 years of probation or, you have to serve out your sentence. So if you're given probation, okay, great. You have to do your probation and then complete it. And then you can get your pardon. That's how it works in Georgia. Now, the neat thing is every single offense that they're facing, so these RICO things, even though it says shall impose prison, there is Georgia case law that says unless the actual statute says you cannot be eligible for probation, the court can always grant probation. So technically, Trump could get probation out of this even if he's convicted of everything. None of it's mandatory. Kenneth saying, can the governor commute sentences? I don't think he can even do that. Well, actually, he could commute sentences, sure, but that doesn't wipe away the convictions. Paul is saying, imagine the look on the appellate court when yes, a little dump truck worth of filings are going to be delivered to them with the trial transcript. 100%. Barton Bell is saying that's a reconstruction holdover. Yeah. And that's an issue because some states, they, when the federal government came through and reconstructed, wanted to limit state power. And some states didn't fix it. Roth is saying, what's the point of a pardon? A pardon is a political, it's part of that, even though the executive branch is in charge of prosecuting people, technically. It is a tool, it's a political tool, and it's something that, it goes back to the time of the king. As a sovereign, the king could pardon you. The king could exercise mercy and say, all is forgiven. Especially like, let's say you were a vassal or some sort of underling and you betrayed the king. If you guys ever, read about like what happened with William the Conqueror when he was running around Normandy as a young lad, a lot of barons and nobles would routinely like join forces or work with like the King of France or other people in the area and start fighting him and allying against him. Well, he had the right to forgive them, especially once he became Big Daddy in Normandy and basically Big Daddy of France, the warlord of France, more or less. He can exercise forgiveness. He can exercise mercy. It's an act. Well, that's something that's held over. Like sovereigns have that act, have that ability. The sovereign has the right if they feel somebody's been done wrongfully. And yes, can it be abused politically? Sure. But that is, if that becomes an issue, people can vote against them. If it turns out they're violating and just pardoning people left and right, you could impeach him. There's ways you can do things. But no, the pardon is an act of mercy, basically, that the executive can use. Generally, like you only use it for people who were wrongfully convicted. Like Jack Johnson, he was a boxer back like during World War I era and in the 1920s. He got convicted of violating the Mann Act because he had his wife at the time was white, and he was accused and charged with taking a prostitute across state lines. Well, he got convicted of a federal crime and it ruined his life and he had to go to prison for it. Well, during Trump's presidency, Trump pardoned him posthumously, saying, the government did you wrong. You shouldn't have had to deal with that. So. Oh, Astaroth saying, I get what it, like, I don't need you to tell me, like, You don't have to sell it to. You're like the guy. What movies like? You don't have to sell it to me. I'm trying to kill someone with it. And what's the point if it can only happen after you've spent your innocence imprisoned? This is a holdover from Reconstruction. When the South lost the Civil War, Reconstruction happened. Basically, all of this Confederacy was under military governance, and generals took over governing areas. Part of the way they wanted to control things was, well, we can't have, a pro-Klansman or a pro-slavery governor running around and then having, lynch mobs and violence brewing everywhere. And you're going to say, up pardon, up pardon, up pardon, up pardon. Nothing ever happens because back then the federal government really didn't have the scope and authority they do now. So it was a way of limiting governmental ability in states from getting uppity again. So that's why they did it. Yeah, they would just pardon everybody. The line is from Battleground. Okay. Captain Bitto says, pardon all their cronies. Pretty much. Amateur Iconoclast says, didn't Jimmy Carter pardon Jefferson Davis and Lee? I don't know off the top of my head. Sierra Fox saying, oh, no. I'll pass. I'll go marry Nancy Pelosi instead. So, well, I think I've kind of caught up on everybody's questions for today, guys. It seems like we 281 people here. Like I said, please, guys, like and subscribe if you enjoyed this today. If you guys are interested, we do this every 30. It's always a fun time. 358 likes. Holy cow. Thank you. 17 thumbs down. But you know what? The neat thing is that still counts as engagement to YouTube. So I'll take it. BS says, will the traitors ever get what they deserve? They'll probably escape man's justice, but they won't escape God's justice. Kenneth saying, actually, today now it's Alabama, Connecticut, Idaho, Montana, Nebraska, Nevada, South Carolina, and Utah are the other 8 states with similar parole boards. Yeah, that's not a surprise. So, thank you, Ken, for that. Charlie's saying that those are the state's attorneys from Georgia not liking it. Yes. Yes. All right, guys. So if that is it for now, I think if we have time tonight, we will go live. If not, see you guys tomorrow night at 9:30 Eastern Standard Time. And until next time, just because you did it doesn't mean you're guilty. Have a great day, everybody.